Okay, let's dive into a place that can be incredibly confusing and, frankly, pretty overwhelming: family court. We're going to talk about what actually happens to your constitutional rights when you walk through those doors. Have you ever been in that situation where you step into a family courtroom and get this sinking feeling that the rulebook you thought everyone played by just doesn't apply here? It's a really common feeling. Well, here's the thing: you're not going crazy, you're not imagining it. There are very real reasons why it feels that way. And we're about to break down exactly what is going on and, more importantly, what you can actually do about it. So it all starts with this idea we can call the constitutional rights gap. And really, getting a handle on this one concept is the key to understanding everything else. Think of it this way: your rights don't just vanish. Instead, they get bench pressed. They're squeezed and compressed down into this much smaller, minimal version called procedural fairness. Why? Because family court is built for speed, it gives judges a ton of discretion, and it's all laser focused on this kind of vague idea of the best interests of the child. I mean, the contrast is pretty stark, right? On paper, you expect these full, solid, robust protections. But the reality you walk into is a system designed to move fast and let the judge make quick calls. This mismatch, this gap, is where all the trouble starts. And here's the catch: this gap isn't just some abstract legal theory. Oh no. It creates a very real, very predictable playbook of manipulative tactics that can be used against you. The most important thing you can do is learn to spot these plays as they're happening. So let's get into it. All right, welcome to what we'll call the Dirty Tricks Playbook. Just knowing these common tactics is your first and best line of defense. Play number one is all about control. Specifically, controlling what's said, what's seen, and what information actually makes it to the judge. It's basically information and speech warfare. So here's what this looks like in the real world. You might see a push for a ridiculously broad gag order, which pretty much neuters your First Amendment right to speak. Or they'll go on a discovery fishing trip, digging through all your private records, hoping to find some dirt, a direct hit on your Fourth Amendment privacy rights. They might even try to box you into admitting certain facts, chipping away at your Fifth Amendment right to not incriminate yourself. Okay, so once they've tried to control the information, what's next? Well, now they start messing with the rules of the game itself. Let's talk about play number two, the process ambush. You ever walk into court for what you thought was just a quick check-in, a simple status conference, and bam, you find out you're suddenly in the middle of a trial? That's called the rocket docket. It's a classic ambush tactic, right alongside getting hit with short notice hearings or having a mountain of new exhibits dropped on you minutes before you start. These tricks are all designed to violate your basic right to be prepared. And that leads us to the third play, which is maybe the most sneaky of them all. It's called narrative capture. And this is a battle for the story the judge is going to hear about you. This is when you get slapped with a label like high conflict or uncooperative, with absolutely zero evidence to back it up. Or you hear what's called hearsay stacking. These layers of the therapist said that the teacher said that he said, without ever letting you question the person who supposedly saw it first. It's also when an evaluator's report is treated like it's infallible, or when someone slips things into a final order that the judge never even mentioned. It's all about making perception more powerful than reality. Okay, I know, that's a lot, and it can feel totally hopeless. But here's the really good news. There is a single, incredibly powerful, universal countermove that you can use against this entire playbook. And that's the million-dollar question, isn't it? How do you actually stand up for yourself and your rights without being painted as the difficult one, the one who's just making trouble for everyone? Believe it or not, the answer is way simpler than you'd think. This is it. This is your three-word shield. I want you to burn this into your brain because it's your framework for everything. Notice, evidence, findings. Now, let's break down what each of these really means. First up, notice. And look, this is so much more than just getting a document in the mail. It means demanding a meaningful opportunity to know exactly what the other side is asking the court to do, so you have a real chance to prepare. This is how you shut down the process ambush. You can simply ask, Your Honor, what specific relief is being requested? Second, evidence. This is your powerful counterpunch to narrative capture. Instead of getting bogged down arguing against vague feelings or nasty labels, you calmly and politely ask the most important questions. Who personally observed this? What is the foundation for this piece of proof? See, you're forcing the conversation away from gossip and back to actual verifiable facts. And finally, the third piece, findings. This is all about accountability. It's about asking the court to show its work. You can say, Your Honor, for the record, could you please state the specific facts that you found to be true which support this decision? This forces everyone to be crystal clear and creates a solid record in case you need to appeal later. So, why are these three little words so incredibly powerful? Well, it's because they fundamentally change the entire dynamic of the courtroom. Using this framework shifts the entire focus. You move the battle away from all the emotional drama and subjective attacks, and you plant your flag firmly on the bedrock of our entire legal system, procedural fairness. Suddenly, you're not arguing about who's a good or bad person, you're arguing about the rules, period. Just think about the difference here. Before, you walk in feeling ambushed. You feel confused. Afterwards, you are calmly and confidently demanding notice. Before, you're trying to defend yourself against all these vague accusations. After, you are methodically questioning the evidence. This is the difference between being on defense and taking control. So if you only take one single thing away from this explainer, please let it be these three words. Say them out loud. Write them on a sticky note. They are your shield and they are your sword. Notice, evidence, findings. Which leaves us with one last big question to think about. In a court system that's all about this subjective idea of best interests, who is ultimately responsible for making sure your fundamental constitutional rights are protected? The judge has a role, your lawyer has a role, but at the end of the day, that person is you.